warm welcome, everyone, to the ASER Institute. My name is Machiko Kanetake, and as the academic director of the Institute, I'm extremely delighted to have your presence today to discuss the current programs and the future direction of private international law in an era of uncertainty, as put it in the title of the event. So as you can see from the program, this year we are celebrating the 60 years of the development of the ASER Institute. And today's conference is one of the important moments to discuss the discipline's current challenges and future directions in complex juridical, political, cultural, and technological contexts. So I don't think I need to remind the participants of this conference that our institute is named after Tobias Aser, who received the Nobel Peace Prize in 1911 for his work in the establishment of the Permanent Court of Arbitration and for his achievement in establishing the Hague Conference on Private International Law. And as my background is public international law, I'm standing here only because my colleagues were kind enough to ask me to say a few words of welcome. But I have the feeling that at least some of the broader challenges we may touch upon today are shared both by private international law and public international law studies. So let me just briefly refer to three of them. The first is a question of territoriality. I understand that private international law accommodates extraterritoriality quite flexibly, at least compared to public international law, where statehood and its territorial reach still dominates its paradigms. So I very much look forward to learning further from you and how territorial boundaries are treated in private international law in order to resolve dispute and provide remedies. And the second thought I had is the extent to which deference or respect is paid to other legal orders. So one of the fundamental questions of private international law, well, say the expert of public international law says, must be about how one country's court finds a point of connection or point of compromise when the courts face the judicial decisions of another state. So this interface perspective, I find it always quite interesting, can offer insights into other domains. For instance, how much difference international court should give to national decisions. So this is also a point of connection. I very much look forward to learning from today's discussion. And thirdly, I'm also curious to learn how the interpretive practices of private international law engage with what International Court of Justice in The Hague recently referred to as an existential threat, namely climate change and its differentiated impact. So climate change litigation and supply chain governance are such important issues for both private and public international law, and I'm eager to absorb insights from today's discussions. And I'd like to end my short welcome remarks by thanking my brilliant colleagues, Vesna Lazić and Eduardo Silva de Freitas. Together with event team colleagues, Vesna and Eduardo put a lot of effort into this conference, and we received many registrations. And as private international law perhaps necessarily requires national focuses, and given that there are so many rich subtopics within this discipline, it can also be challenging, I would imagine, to maintain and develop a broad scholarly network in private international law. So I very much hope that today's conference will be one of many occasions that we meet as scholars and practitioners of or about private international law, and the ASER Institute is, of course, ready to support such initiatives. So with this short remark, I would like to give the floor to Vesna, who leads private international law research at the Institute. So, thank you.
Ladies and gentlemen, dear colleagues, friends, honorable guests, it is both pleasure and privilege to welcome you today to this conference at the Acer Institute, also on behalf of my Acer colleague Eduardo Silva de Freitas and other colleagues whose research includes the issues of private international law. This event is a part of a very special occasion, that is a 60th anniversary of the Acer Institute. Today's conference, Adapting Private International Law in an Era of Uncertainty, is our private international law contribution to a wider series of seminars and events organized by the Acer community in various fields of its expertise to celebrate the Institute's 60th anniversary. The Institute was founded in 1965 by a group of scholars led by Bert Voskuil, a dedicated private international law lawyer, widely regarded as the Institute's founding father and its first director, the position he held for almost 30 years. I had pleasure and honor of working with Bert before joining the Acer Institute. And our fruitful professional cooperation and friendship continued well beyond his retirement. The Acer Institute was initially established as an inter-university center in the following fields of law. Initially, in the field of private international law and European economic community law, nowadays European Union law, soon extended to public international law. Given that scope, it is indeed, as already we heard just before a few minutes, it is no surprise that the Acer Institute was called after Tobias Michael Karel Acer, a private international law scholar, a diplomat, and a receiver of the Nobel Prize for Peace. His remarkable academic work, but also diplomatic efforts, greatly strengthened the Netherlands' standing in international affairs. His contribution also played a vital role in attracting key private international law institutions to the Netherlands, and to The Hague becoming what we today know as the legal capital of the world. So his vital role is stand out in two achievements, I should say. One is to bringing the permanent bureau of the Hague Conference on Private International Law and the Permanent Court of Arbitration to The Hague. In this moment of reflection and celebration, I would like briefly to acknowledge the Institute's role in shaping research and education in the field of private international law over the past 60 years. This is not an attempt to summarize the achievements of the Acer Institute, but rather a recognition of several initiatives that have had a lasting impact. Since its founding, the Institute has played a central role in promoting and facilitating research, education, and documentation in private international law in the Netherlands and internationally. It has held a prominent place among academic institutions, fostering scholarship and publication through journals such as Netherlands International Law Review, NIPR, European Business Organization Law Review. Amongst many former publications, I must mention the Hague-Zagreb Colloquium and later Hague-Zagreb-Ghent Colloquium series. These volumes feature contributions from leading private international law scholarship around the world, capturing discussions from biennial conferences held between 1977 and 1990. In terms of academic quality and global participation, it would not be an exaggeration to say that their influence parallel that of those of Journal of Private International Law conferences today. The Institute's collaborations have extended beyond academia to include governmental and non-governmental organizations at the both national and EU levels. The Dutch Ministry of Foreign Affairs consistently recognized the importance of the private international law and provided essential support for numerous research and educational initiatives. One of the most important ones and notable examples is Acer College Europe program. Through almost 20 years of that program, many young scholars, PhD candidates, researchers from the EU candidate countries had an opportunity to stay at the Asser Institute and conduct their research here, and also to follow a course on international commercial law developed by the Asser Institute in cooperation with the steering committee of partnering universities. In doing so, the Asser Institute played a modest yet meaningful role in advancing EU integration. For our collaboration with the European Commission, it dates back to 70s, as I heard just this week, by an old friend of the Institute, Belgian Professor Emeritus. European Commission at that time approached the Asser Institute in connection with the establishment and maintenance of the database of the ECJ case law on Brussels regulation. Nowadays, more recently, we are proud of results of the research projects in cross-border family matters and in the Judge Trust project, both of which the Asser Institute coordinated. And now in the current project of PAX project, which is coordinated by the University of Antwerp. It is both rewarding and encouraging to see our research recommendations being found back in the instruments of the private international law of the European Union, such as Brussels II terror regulation, and also reference of the Commission in this document of this year in the report referring to the Judge Trust project on the occasion of Brussels I bis regulation. Equally important is the Judge Trust impact on the education. It laid the foundation for what now is the first moot court competition in private international law. The inaugural edition took place here at the Asser Institute in 2019, followed by an online another moot organized by the University of Antwerp. From 2021, it evolved into the PAX moot court competition led by Antwerp University, with the Asser Institute as a proud partner, alongside with the universities of Barcelona, Dauphine, Maastricht, Ljubljana, and Sofia. The title of today's conference reminds us that we indeed live in a time of significant global change and enduring uncertainty. This is a time of political instability, climate change, migration, environmental calamities, digitalization, artificial intelligence, and disruptive technologies. Indeed, they all invoke multiple significant legal connotations and issues, and most of them are most likely to trigger also ethical, political, economic, and social questions and debates. Legislators, lawyers, and academics alike are facing and will be facing greater challenges in finding appropriate legal models to accommodate such emerging changes. Needless to say, the legal challenges for private international law lawyers will be greater, considering that cross-border implications usually generally further complicate legal transactions and legal relationships. Today's conference aims to explore how private international law can and should respond to current uncertainties and emerging challenges. Following the keynote address, our first panel will focus on the challenges brought by the digital era. One of the key topics will be interplay between the European Union substantive law and private international law instruments such as Brussels I bis regulation, Rome II and Rome I and Rome II regulations. We will also receive an update on the work of the Hague Conference, influence of digitalization on the existing conventions, but also overview on the current legislative projects. Furthermore, the panel will explore how technological achievements and advancements are reshaping the boundaries of private international law. And finally, we will also be presented with some practical difficulties that users of online platforms for international dispute resolution that they face when using a technology in dispute resolution. excuse me. The second panel will be discussing various aspects of the protected or so-called weaker parties. Unfortunately, Professor van Kalstem is unable to join us today due to unexpected family matter. However, he was kind enough to send his paper and also to share with us his PowerPoint presentation, which will be available through a QR code that will be added at the end of the second session. Hopefully, we will also benefit from insights on the developments of models of protection of weaker parties from the UK perspective. IK, hopefully, because unfortunately Professor Grušić was delayed. His flight was cancelled last evening, so he could not have arrived yesterday. He is on his way and hopefully departed from Paris this morning, and he will be just on time for this panel. During that discussion on the protection of weaker parties, we will also, of course, get an insight from the European Union perspective and also try to assess how satisfactory is the current legal framework of the European Union in that area. Also, we will be examining the regulation on small claims on 2 occasions during the first panel, because the problems in facing the online dispute resolution will be seen from the perspective of the small claims regulation, and also it will be briefly addressed in the second panel in assessing the level of protection provided in that regulation. The third panel will cover 2 timely topics. It will address the questions of the applicable law in the context of combating stretched lawsuits against public participation, and assessing whether the proposed anti-SLAPP directive is likely to achieve its intended goals and objectives. Second, we will consider whether large language model applications can serve as a useful research tools for conducting conducting research in the field of private international law. We are both honored and delighted to welcome such an outstanding group of speakers and moderators. Thank you all for joining us today and for being here for this special occasion. We look forward to what promised to be a rich and timely exchange of ideas. Thank you. And now I would like to warmly invite Mr. Hans van Loon to deliver a keynote speech. Given the long-standing cooperation between the Arthur Institute and the Hague Conference, I'm especially pleased that Hans accepted our invitation to speak on this important occasion. There is no need for a lengthy introduction to us. We all know Hans and his remarkable contribution to our field. Let me simply mention that he is the former Secretary General of the Hague Conference, a member of the International Law Institute, and has held an honorary doctorate from the University of Osnabrück since 2001. Hans, the floor is yours.
Thanks very much, Vesna, for your kind introduction. I'm very grateful and honored to have been invited to deliver today's keynote speech. And of course, I extend my warmest congratulations to the Arthur Institute on its 60th anniversary. It also brings back memories of the invitation I received 20 years ago to say a few words when the Arthur Institute celebrated its 40th anniversary. The keynote, everyone may have forgotten that, the keynote speaker at the time was Rosalind Higgins, then president of the International Court of Justice, who spoke about 40 years of public international law. And then I followed her as Secretary General of the Hague Conference with 40 years of private international law, and Jaap de Zwaan then director of the Klingenthal Institute, closed the line with 40 years of European law. And a nice booklet was published. It's still worth reading, which includes all these speeches. In her keynote, Rosalind Higgins listed progress in various areas of public international law since the end of the Cold War in particular. But she ended up on a more somber note when she spoke about the shortcomings of the collective security system established by the Charter of the United Nations, the prohibition of the use of force and the right to self-defense. Remember, that was in the time of the invasion of Iraq, which she didn't like. And she concluded, and I quote, "We have, in my view, entered a period of increasing uncertainty about the fundamentals of the international legal order." So in retrospect, we can say that Rosalind Higgins' words heralded the beginning of the era of uncertainty referred to in the title of our conference. Today, we are witnessing even more intense unlawful use of force and more intense abuse of the right to self-defense, leading to appalling violations of humanitarian law and untold suffering. In addition, we are seeing a breakdown of the multilateral legal trading system, increasing inequality between countries and within countries, a doubling of the number of displaced persons over the past decade, serious environmental degradation, depletion of resources, loss of biodiversity, and most fundamentally of all, the existential threat of the unabated continuation of global warming. Now, in this bleak scenario, is there still a constructive role for private actors, private law, and private international law? Or is it solely up to public actors, states and public international law to contribute to better global governance? Tobias Asser would have been surprised by this question. Asser, as Vesna mentioned, played a prominent role in the interstate negotiations on the Suez Canal, on the Congo question, the Hague Peace Conferences, and at the same time he promoted private international law and founded the Hague Conference on Private International Law. And he switched effortlessly between public and private, public international law and private international law, disciplines which to him merged into one another. And the Asser Institute owes its broad mandate, public and private international law, as well as European law, to Asser's versatility. Unfortunately, much of Asser's holistic cosmopolitan vision was lost with the rise of nationalism, with its perverse excesses, which already started in Asser's time. And as a result, his and Mancini's and Savigny's international approach gave way to a conception of private international law as part of national law, distinct from international public international law. This divergence of public and private international law, despite occasional interfaces, still plays us tricks today. It has left private international lawyers blind to its larger international context and created a sort of insulated regulatory space for private interactions. I borrow this word from Alex Mills. And at the same time, it has left public international lawyers blind to the actual and potential functions of private international law in global governance. Of course, we should not overstretch the role of private international law in global governance. Private law, private international law offer no solace when it comes to Rosalind Higgins' concerns about the collective security system of the UN Charter. But, on the other hand, private international law is relevant to another important part of the Charter, namely Chapter 9 on international economic and social cooperation for a higher standard of living, full employment, and universal respect for human rights, among others. Private international law is of importance to these objectives, although those who drafted, few people may have had private international law in mind when drafting the Charter of the United Nations, which incidentally came into force exactly 80 years ago on the 24th of October 1945. Something to remember. Now here the project, the private side of transforming our world comes in. What's that? Well, 10 years ago, in September 2015, the United Nations General Assembly adopted the 2030 Agenda for Sustainable Development, Transforming Our World. And it offers a plan, and I quote, for people, planet, and prosperity, with 17 goals for global action until 2030, or two-thirds now. The Sustainable Development Goals, the SDGs. The agenda is not only aimed at states, but also at civil society, the business community, and the private sector, academia, all people. However, the agenda seems to focus primarily on public actors and states for its implementation. It refers to various treaties of public international law, but the role of private international law is not addressed at all. And yet, many of the problems that the agenda aims to tackle are both caused and can be solved by private action, private law, and indeed the SDGs presuppose the functioning of private international law in cross-border situations. Now, this absence of private international law in the United Nations agenda prompted Ralph Michaels and Veronica Ruiz and myself to set up a global project to investigate the actual role of private international law in global governments, its hidden role, so to speak, and its potential to change our world in our era of uncertainty. We began by calling for papers on the role and potential of private international law in relation to each of the 17 Sustainable Development Goals. We expected a dozen or so papers, and we got more than 130 proposals from all over the world. That led to a conference at the Max Planck Institute in Hamburg in 2020, which resulted in the book, The Private Side of Transforming Our World, with contributions from across the globe. It is also accessible online freely, open access. The Hamburg conference was then followed by 3 regional conferences on private international law and sustainable development, one in Latin America in Asunción in 22, one in Asia in Wuhan last year, November, and one in Africa in Pretoria in July of this year. And the conferences in Latin America and Asia have resulted, again, in open access publications online. The conference in Wuhan also in a nice paper journal, which I received this week. And the publication about the Pretoria conference is in preparation. 3 main findings emerged from all this. First, the idea that private international law has a role to play in achieving 2030. That idea has resonated with scholars across the world. Second, many contributions share the feeling that in our quest for a more sustainable world, there's generally too much emphasis on interstate relations, interstate liabilities and remedies, and too little on access to justice and remedies for private persons. And third, many feel that private international law urgently needs to become more aware of the Sustainable Development Goals of the Agenda 2030 and to commit itself more to their achievement and, if necessary, reconceptualize itself. Now, if you agree, I propose that we look a little more closely at each of these 3 findings. First, the fact that the project has attracted private international law scholars from around the world suggests that what has been called the global turn in private international law is starting to gain traction worldwide. And to see this in perspective, remember that only 60 years ago, when the ASSE Institute was founded, private international law was essentially a branch of sport practiced in Europe, the US, and to some extent in Latin America. It was considered a somewhat marginal part of national law. Subsequently, we saw the development in Europe of a regional European dimension to private international law, reinforced by the transfer of legislative powers in the field of private international law to the European Union through the Amsterdam Treaty 1997. 10 years later, 2007, the European Union became a member of the Hague Conference, which enabled the EU, empowered the EU to act as a global player in the conference's unification work. And this, in turn, gave a boost to the Hague Conference's global role. The EU played a prominent role in the negotiations on the Choice of Court Convention, 2005, the Convention for the Support of Child Support, 2007, and the 2019 Judgments Convention, and continues to be very active. And moreover, the EU played a significant role in bringing these conventions into force at the global level. Now you see the idea of a global horizon of private international law, its global turn, is only a relatively recent realization of the impact of globalization on private international law. And what I find so encouraging is that our project confirms that this global perspective apparently appeals to private international scholars worldwide and opens up possibilities for dialogue, reflection, and cooperation across the world. Let me give you an example. In his contribution to our book on Sustainable Development Goal number 6, Clean Water and Sanitation, Richard Oppong, who is from Ghana but teaches in Canada, refers to litigation in the global north, such as the Vedanta case in the UK, concerning environmental damage caused by subsidiaries of parent companies in Europe in Africa. Oppong admits that allowing such lawsuits against multinationals in the global north can be useful. It gives individuals and communities access to justice, even if they are in the global south. At the same time, he argues, litigating these claims outside the states where the harm occurred comes at a cost. It comes at the expense of empowering these states' judicial and legal systems to develop the necessary expertise in handling those claims. It might be another form of environmental colonialism. And I believe that Oppong has a point here. He makes us reflect on the obviousness of the Brussels-Lugano jurisdictional system with its rigid grounds of jurisdiction. There's much to be said for that system, and I would not plead for the introduction of forum non-convenience that would weaken the system. Rather, we should think of mechanisms for judicial communication and cooperation, including perhaps joint hearings between courts in different countries, which are currently, I believe, being discussed in the Hague Conference parallel proceedings project. Or even we might think of mechanisms for the transfer of jurisdiction as we have developed them in the 96 and 2000 Hague Conventions on Protection of Children and Adults. The second finding of our project was that many share the feeling that in our quest for a more sustainable world, there is too much emphasis on interstate relations, liabilities and remedies, and too little on access to justice and remedies for private actors. And this confirmed our feeling that the Sustainable Development Goals and most global instruments relevant to the SDGs tend to have a blind spot for the role of private international law. In his chapter on SDG 14, Life Below Water, Tajuddin Sani from South Africa argues that the Convention on the Law of the Sea, UNCLOS, although it is called the Constitution of the Sea, does not provide standing access to justice and remedies for local communities suffering harm in the marine space. Instead, UNCLOS leaves it to states to make recourse available in accordance with their legal systems for damage caused by pollution of the marine environment by natural or legal persons under their jurisdiction. But it doesn't work, Sani argues. What we need is a full and effective private international law regime of responsibility, accountability, and liability. And he makes similar observations on the 1992 Convention on Biological Diversity, which also leaves it to states to make recourse available for a private individual. Now, if we look at climate change, we see that neither the 1992 UNFCCC, the Rio Climate Convention, nor the 2015 Paris Agreement provide civil or administrative mechanisms for remedies for citizens. All these important global international instruments would better achieve their goals if they did not depend only on states for their implementation, but also created space for private legal action and would include uniform rules on private international law. At least think about that. Now, what is so interesting is that both the Rio Convention and the Paris Agreement have been successfully invoked by citizens in their cases against both governments and companies. Starting with the famous Urgenda case 10 years ago, and also in the Milieu Defensie Shell case, climate case, Dutch courts have accepted that these treaties, UNFCCC and Paris, although they formally bind states only, have a reflex effect in Dutch civil tort law, and we see similar developments also in other states, in other countries around the world. Another example of too much emphasis on interstate relations and too little on access to justice and remedies for private actors comes from a different field, cross-border labor. The program of the International Labour Organization, ILO, is central to SDG 8, which is about promoting full and productive employment and decent work for all. However, as Ulla Jukkonen from Finland notes in her chapter, the ILO has not focused on the transnational dimension of decent work. It's concentrated on what happens in every state. 40 years ago, the ILO commissioned a survey on the law applicable to international employment relations, but Felice Morgenstern, but there has been no follow-up. So there remains an urgent need for a global system of private international law to ensure adequate protection of labor rights in transnational situations. And we are speaking about 170 million migrant workers in the world. If we move from the global to the regional level and turn to the European Union, there is no doubt that the EU has made important strides in private international law, building in the beginning especially on the work done by the Hague Conference. The Corporate Sustainability Due Diligence Directive, the CSDDD, enacted in July 24, establishes parallel to a public law supervision system, parallel to that, a civil liability regime for adverse impacts on human rights and the environment. And in order to create a level playing field, that civil liability regime not only applies to companies domiciled in the EU, but also to companies domiciled outside the EU, which are active on the EU market. Surprisingly, however, the directive does not establish the necessary private international law rules for lawsuits involving such third country-based firms. And that's a problem, because Brussels 1A does not offer either a common forum to sue such third country companies, but leaves it to national law of member states, so there's no uniformity. And the same applies when it comes to suing subsidiaries and suppliers based in third countries, together with the lead company based in a member state. That is also left to national law. And with respect to choice of law, applicable law, The choice of law option of Article 7 of the Rome II regulation, which gives victims an option to choose between the law of where the damage occurred and the law where the event causing the damage occurred, that option is available only in environmental cases, not in the case of human rights violations. And that is why the Groupe Européen de Droit International Privé made proposals to fill this jurisdictional and applicable law gap in the CSDDD, but so far without success. It's worth noting in this connection that the CSDDD builds on the UN Principles on Business and Human Rights, the UNGPs or the Ruggie Principles. Now, there we have, in my view, a very, very encouraging example of the coming together of the public sphere and the private sphere. The Ruggie Principles require companies to exercise due diligence in respect of human rights and, in fact, give companies, private entities, responsibilities which used to be the competence of public authorities. Okay, UNGPs are not binding, they are soft law, and yet they break through the insulated regulatory space for private relations, and they offer a hook for private and private international litigation on human rights and the environment, including global warming, as we've seen in the Milieu Defensi versus Shell case. And this brings us to the third finding of our project, that there is an urgent need to make private international law more aware of its role in the global legal architecture and more involved in the achievement of the Sustainable Development Goals, the Agenda 2030, our global roadmap, and the only global roadmap we have at the moment. Perhaps also the private international should reconceptualize itself to that field. Now, in some fields of private international law, this awareness is already alive. In others, it's still dormant or even absent. If we look at persons and families, the widely embraced Hague Children's Conventions on child abduction, protection of children, adoption, support, reflect a worldwide realization of the need to coordinate the diversity of rules on protection of children and families and to enable direct cooperation between courts and authorities across borders. And these conventions are influenced by international and regional human rights instruments, especially the 1989 CRC, UN Convention on the Rights of the Child. And these instruments help give effect to those human rights instruments across international borders. So this is the vertical dimension, so to speak, of private international law, which you see at work here. And there's more to do in that respect, because few people realize that when the covenants, the UN covenants, for instance, refer to the right to marry or the fair hearing, there is a private international law aspect to that. And that needs to be further developed. And in this regard, I may recall the resolution of the Institut de Droit International on Human Rights and Private International Law that was adopted in 2021. So in addition to this vertical role of private international law, of course, private international law continues to fulfill its vital horizontal function as a system that is very important to acknowledge the variety of legal cultures and systems in our world and tries to reduce conflicts between them. However, more awareness and work is needed to make private international law fit for sustainable development. Let me mention two rather fundamental issues that currently present a challenge for private international law. The first is our traditional focus on individuals and individual entities rather than on collectivities. And the second challenge concerns party autonomy and its limitations. Historically, private international law is focused on individuals and individual entities and is not calibrated to collectivities. This is a problem in several areas of private international law. First, in the field of civil legal action by groups of concerned citizens in consumer cases like the Dieselgate scandal and in environmental and climate change cases. Very often, such cases have cross-border dimensions. But as it stands, private international law is not fully developed to deal with such issues when they come up. The second, I'll develop that in a moment. The second example of the need for private international law to focus more on collective entities concerns the cross-border regulation of responsible business conduct of companies in a value chain. We already touched on that in the discussion of the CSDD. And there again, private international is struggling to fully capture the operation of the various actors in the value chain. A few remarks on both examples. First, on the collective proceedings. Brussels I, the Hague Choice of Court Convention, the Hague Judgments Convention, all basically follow the pattern of aulus agerius, suus, numerius, nigidius, individual against individual. Yes, they also apply to collective actions. They are not excluded, but not without problems. Is an action brought by a competition authority against a company a civil or commercial matter? Question of characterization. What about admissibility and a way to determine the represented group? And therefore, proposals have been made, including by Burkhard Hess and his team, to reform Brussels I to adapt it to collective proceedings. Very good. However, that is easier than reforming Hague Conventions, because that's a complicated process, much more complicated. We are sometimes jealous of the EU for being able to modify its regulation and directives. We are not at the Hague Conference. So some problems can be solved through interpretation, but not all of them. But as I say, reforming a Hague Convention is, I won't say a nightmare, but is complicated. So anyhow, adaptation of private international law will be necessary, in my view, in regard to collective proceedings. Coming to global value chains, they are under scrutiny, including from private international law. I already mentioned how Vedanta illustrates that parent companies in the global north can be sued for damage caused by their subsidiaries in other continents, in Africa. In the UK, there's also the case of Okpabi and the Dyson case recently, and in the Netherlands we have seen the cases of the Nigerian farmers, Akpan and others, against Shell. Now, the intention of the CSDD, this directive of the European Union, was to create a uniform civil liability standard for companies regarding their adverse impact on environment and human rights in the value chain. If the lead company violates this standard, it is liable for damage caused by its subsidiaries and business partners throughout the value chain. However, in January or February this year, the Commission published its Omnibus Directive, in which it proposes to delete this uniform standard, leave it to national law. It narrows the due diligence requirements to apply only to the company's direct business partners, tier 1, not down, further down or up. And the proposal also deletes the overriding mandatory application of the liability rules. Now, if this proposal succeeds, and it seems likely, there was a vote on Wednesday this week, which was not conclusive. There will be another vote in November in the Parliament. But if this proposal succeeds, as it seems likely, then the result is obviously that private international law regains its full role. Because if you narrow substantive private law, then questions of private international law pop up. And that makes the proposals that we made in the GDIP on jurisdiction and applicable law all the more, even more necessary. But above all, it raises again the question of how to strengthen the lead company's responsibility for negative social and environmental impacts in the value chain. Now, the way forward here, I think, would be to further develop the idea of the global value chain, not as a train of different wagons, but as a single entity, governed by the lead company, so that negative externalities can in principle be attributed to the lead company. Now, this requires important adjustments to substantive private law, but also it's relevant to private international law, jurisdiction rules. For instance, an extension of Article 8.1 on related actions to defendants based in third countries. It would help a great deal if there were a uniform rule in Brussels I that enables you to sue the parent company based in Europe and subsidiaries and others based outside the EU. Finally, a word on party autonomy. Not surprisingly, party autonomy and its limits have emerged as a major theme in our project, The Private Side of Transforming Our World. Party autonomy in private international law, whether by choice of court or arbitration or by choice of law, is a way for parties to create advantages and wealth for themselves. And not so long ago, party autonomy in private international law was hailed as a principle with human rights status. Think of the, I believe, Cairo resolution of the Institut de droit international, an idea of Eric James. And there's no doubt that party freedom in cross-border situations is a huge achievement, endorsed in the commercial sphere by the Hague Conference's 2015 Principles on Choice of Court in International Commercial Contracts. But we have now also become more aware of party autonomy's negative effects on human rights and on the environment. And several authors in our book therefore argue that public policy and overriding mandatory rules should curb such excesses. But the problem is that these corrective mechanisms, overriding mandatory rules ex ante and public policy ex post, that these mechanisms refer to essential domestic values and generally those of the forum, perhaps also the EU, but not to global values. So the question is there a way to give effect to global human rights and environmental norms, including for climate change, even when they are not embodied in the domestic law forum? In climate change tort cases, we have recently seen how in private tort litigation, global norms such as the Paris Agreement, although Paris itself does not bind individuals but only states, such global norms can nevertheless have effect and entail responsibilities also for companies. I refer, of course, to the Milieu Defensie Shell case in the Hague Appeal Court. If this is possible in tort law, is it possible also in contract law for certain fundamental global norms to set limits to choice of court or choice of law, even if those limitations are not expressed in domestic law? Interestingly, the CSDD defines adverse environmental and human rights impact by reference to a whole list of global conventions in two annexes, irrespective of whether those conventions are in force for the EU member state concerned. And here, possibly, lies the beginning of a global standard for at least some aspects of sustainable development. In any case, here again, there is important follow-up work waiting for us to adapt private international law to our era of uncertainty. I must conclude. The ongoing project, The Private Side of Transforming Our World, has shown that the link between private international law and sustainable development is increasingly seen as a new field both for research and for global action. It has brought to light the important role that private international law already plays in global development, but also how private international law can hinder that development. Private international law can no longer ignore important dilemmas, such as the tension between economic growth and development, the sustainable development. The project also demonstrates private international law's potential and the urgent need to build at the global level on the work already done at the regional level, particularly in the European Union, in areas such as cross-border labor and environmental damage. And in my view, there's also a special role here for learned societies such as the EAPIL, the GDIP, ASADIP, and the new Australasian Association of Private International, an initiative from Australia and New Zealand, including by feeding those global organizations, like the Hague Conference, UNIDROIT and UNCITRAL, with proposals for bold global legislative work. I made a proposal for this at last year's EAPIL conference in Poland on private, international and global crisis, that resonated with the organizations, with the organizers, and was picked up again in the ASADIP meeting in Rio de Janeiro in August. In any event, there remains for all of us a lot to reflect on and to do regarding the adaptation of private international law in an era of uncertainty. Thank you very much.